Miss Elston is allowing teenagers to not call their father dad, but they call him Clark.
We're set today. I have this down as a status hearing. What's on file is a motion filed by Mr. Kidwell on behalf of his clients, a motion to modify custody, parenting time, and child support. And then there is a subsequent motion, an affidavit for contempt. And essentially, what we're doing today is trying to figure out what we need to do to resolve these matters. And Mr. Kidwell, I know we've had some off-record discussions, but if you could go ahead as the filer of these motions, provide how you think the case should move forward at this point.
Would you prefer I know that the court has read this, and of course, Miss Elston advised that she had read it and she's seeking counsel. So I didn't know if you wanted me to physically today move forward or talk about a possible way we can have a third party observe this, Your Honor.
Okay, let me, Miss Elston, you're wanting to seek or try to hire an attorney, is that correct?
Yes.
Okay.
I mean, if he is he talking about doing like a mediation type deal?
That's been discussed, the possibility of doing that. Now, if that's something that you're agreeable to and want to make that decision without the benefit of counsel, we can certainly do that. If you want to visit with an attorney before making that decision, then I would more than likely give you that opportunity as well.
Yes, please.
So which option?
To be able to seek counsel and get advisement on whether or not this would be better handled in a court setting or if mediation would be better.
And Your Honor, as we previously stated off the record, retired Judge Powers does domestic conciliation, which of course by statute includes the attempt to have and work out whatever mediated issues can be worked out. And then of course in the domestic conciliation process, the court would make the DC would make a recommendation as to those issues. But for the benefit of Ms. Elston, I would advise that that's why the statute had been rewritten so that it explained specifically what the purpose of a DC is. And based on that, that's why I had suggested retired Judge Powers. Okay. He's very effective at what he does. Otherwise, since she would like counsel, do you want to do this by status again on the new Zoom code, or how would you like to do that?
What I'd like to do is probably set this out about 30 days. That way, Miss Elston would have time to consult with an attorney. And if after doing so, you all decide to go into domestic conciliation, then we can certainly speed that process along. We do have our own local rule 16, which is our domestic conciliation process. Do you have a copy of that, Mr. Kidwell?
I do, but it's not in front of me.
Okay. And Miss Elston, I'll have my AA send you a copy of our local rule 16, just so you will have that and you can read through it. And that's the domestic conciliation process. I'm not ordering that right now, but that's something that is often done on these types of cases to resolve custody type issues.
Your Honor, the only pending urgent issue obviously is the visitation. And as you have read the very detailed notes, my client is still having issues Miss Elston is allowing teenagers to not call their father dad, but they call him Clark. They're not allowing or enforcing visitation. She's made it clear that they can make their own decisions. We all know that every single order from Sumner County and anywhere else states that that has to be followed. She discusses the court papers with the children. She discusses adult matters with the children, and he hasn't seen him in over a year. So that's why we were hoping that the court would enforce some kind of visitation until she either gets an attorney or she agrees to go to domestic conciliation.
Well, without litigating the whole issue, and this being a case that was transferred from Sumner County, I don't have the benefit of having the history and knowing how things have gone along. I'll just advise both parties that if the orders that are in place are the current orders, and those need to be followed. And
that's why we filed the contempt after the motion to change custody, because we just assumed that this would be something to restart or make people think that blatant disregard of court orders in Sumner County and now obviously here continues. So thank you.
And I'm not making any ruling on the contempt. All I'm advising both parties is there's court orders in place. Those need to be followed unless this court modifies them. And right now there's been no modification of any court order. So any court order on file that contains a parenting plan, child support, all of that needs to continue unless modified at some point in the future. So I don't know if that satisfies your inquiry, Mr. Kidwell, but that's
it does, because this court is now making the same findings that the Sumner County Court had made, and we'll see what happens after today's hearing. What day would you like us to come back?
Angela, if we could get a date, about 30 days, probably just like a 30-minute window.
And Your Honor, while Angela's looking at that, there was something I wanted to request on the record in my capacity as the court trustee.
Okay. And I apologize, Mr. Andrews. I kind of ignored you there.
That's okay, Your Honor. Your Honor, the last order filed when the case was still in Sumner County regarding the issue of child support was August 14, 2024. And that order essentially, this was on a prior contempt citation for non-payment of child support. My understanding is that essentially the court was just setting these on review hearings to ensure that child support that was ordered was being paid. The last journal entry was a journal entry notice to appear that set the matter for further hearing on November 25, 2024 at 9:00 a.m. for child support review, and further directed that Mr. Rothkid make payments in the amount of $1,127 per month through the Kansas Payment Center. What I would request is that the court order that essentially confirm that Mr. Rothkid is to continue paying at $1,127 per month until further order of the court. I'm not requesting because it does appear from the Kansas Payment Center records that he has been making those payments.
Yes.
That the matter be set for another review hearing on the child support, but instead just essentially that there be an order stating that he will continue to pay that amount until further order of the court. And if I would just ask if I would be allowed to journalize that confirmation of that prior ruling from today's hearing date. And then I would still plan on appearing at the future hearing since there is a pending child support modification request. But that would resolve the issue that had originally led to me filing the request for a status conference.
All right, Mr. Kidwell, do you wish to be heard on that issue?
We have no objection. He's continuing to pay.
All right, Miss Elston, do you have any comment?
No, I don't.
Okay, that will be the order of the court, Mr. Andrews, if you want to journalize that. Essentially, every order that's been made out of the Sumner County court will continue unless modified in the future by this court. All right, let's go ahead, Angela, if you could propose some dates, please.
April 11th at 1:15.
April 11th at 1:15.
Your Honor, I'll be in a City of Wichita trial from 1 until 4 on April 11th. So I'm unavailable that date.
April 18th at 1:15.
I am not available at that time.
Your Honor, I'm available that date, but I understand Mr. Andrews isn't.
All right, well, you had an April 15th date?
Yeah, April 15th at 1:15.
Unfortunately, I have a 1:30 that day.
I'm available that date also.
April 21st at 10.
Unfortunately, I'm in a preliminary hearing that morning.
How about 1:15?
I am available at 1:15.
And Your Honor, I'll be in Harvey County at 1:15. Sorry.
April 29th at 10.
I'm available.
Your Honor, give me 1 second. I think I will already be in Butler County the 29th at 9 a.m. So obviously I'll be available.
Okay, and I intend to do this as a Zoom status conference, April 29th. And what time did we decide on?
10 o'clock.
All right, now if during that time period, Miss Elston, you get an attorney, the attorney visits with Mr. Kidwell and you all come up with some sort of an agreement for domestic conciliation or so forth, you can submit that to the court and we can get that process going if that's what you all decide to do. And I have no objection to whoever you all choose. If you all can agree upon a domestic conciliator, I typically allow the parties to do so. If the parties are unable to come to an agreement on one, then I'll do one. I'll choose one. And Miss Elston, we'll send you a copy of our local rule 16, so you'll have that and you can provide that to an attorney that you hire in the event that he or she wouldn't have that. Mr. Kidwell, do you need us to provide you another copy of that, or do you?
Yes, Your Honor. I would also be able to forward that to my client. Miss Elston, if you speak to an attorney and you decide you don't want an attorney, please let me know. And then we can discuss further options as the judge just indicated. And Your Honor, you've already said that any and all parenting time orders are to be followed regardless until when we come back. Is that correct?
That is correct.
Thank you, Your Honor.
All right, anything further we need to address today, Mr. Kidwell?
Not at this time.
Miss Elston, do you have any questions?
No, I don't.
Okay, Mr. Andrews?
No, Your Honor.
All right, well, I hope you all can work together and come up with some agreements. If not, then we'll figure out what we need to do moving forward.